Okay, our next case is Mercury Insurance Company versus Markham.
Good afternoon. May it please the Court, my name is Anthony Russo. I represent Mercury Insurance Company. I'd like to reserve 5 minutes of my time for rebuttal, please. I'd also like to thank the Court and my opponent for rescheduling the argument for today.
Mr. Russo, before you begin, and I sincerely apologize for bringing this up now rather than earlier, but frankly, our serious study of these cases is just before oral argument so that we can be prepared and most benefited. But I have a question. There's a question in my mind as to whether or not we have a jurisdiction to review this order. I know that under 9.110 sub M, there's a provision there for review of judgments that determine the existence or non-existence of insurance coverage in cases in which a claim has been made against an insured and coverage thereof is disputed by the insurer. But, and that grew out of Canal Insurance Company, which I guess we all remember, but that was a third-party claim.
That's right.
And this really isn't a third-party claim. I mean, this is a first-party claim. I mean, we don't have someone suing your insured, as the rule says, in this case, because your insured settled, as I understand, and then your insured assigned, and you really have a first-party action by the assignee here.
That's correct.
And really, that's not what the reason was for this rule, if I'm remembering it correctly.
Well, it meets the literal requirement of 9110M because there was a claim made against the insured and the determination of insurance coverage. And
yeah, but it says it's not all it says. It says existence or non-existence of insurance coverage, and it says in cases in which a claim has been made against an insured.
And when what has been made?
Well, not in this case.
There was a loss. That's right. There was a lawsuit by.
Right, but it's not in this case. That was in a different case.
Well, I'm not sure, Your Honor. I'm hesitating because I'm unclear about the procedure by which, and I don't want to misspeak about whether there were two suits or how the two suits were tied together.
Well, and I'm not completely certain either, but I tell you what I'd like you to do, and I don't want to take any more of your time, but what I'd like to ask you to do, and I'd like to hear from Mr. Rosenblum on this too, and I want to give him an opportunity too, because I know you're being caught cold here.
Certainly.
But it would be very helpful if you could submit something within, say, 10 days to explain why a first-party action, which is what this looks like to me, unless I misunderstand what's going on here, comes under 9.110M to make this a reviewable order under that subdivision. If you could give us something within 10 days, and then we give Mr. Rosenblum 10 days to respond to that, and then we'll have the benefit of your views on that, okay?
Certainly.
Let me make one mention in that response. I think that you should particularly look at the committee note adopting the rule where the court said, the Supreme Court adopted the committee note 1996 amendment that says expedited review in the manner provided in Rule 9130 is available for such judgments in cases where a claim against the insured is pending.
Pending.
Is pending. And early resolution of the coverage issue is in the best interest of the parties. I think that's key to further interpretation of the rule.
That's under the committee note in relation to the 1996 amendment, and I'll bring to your attention, and the reason it might have been overlooked is the committee note refers to subsection N rather than M, but it's apparent from the text that follows they're really talking about subsection M there, and it looks, as Judge Davis says, it looks to me like as well that they're really talking about a situation where there's a pending, in this case, lawsuit against an insured.
It sounds like that would be the determinative point.
Yes.
It looks sort of that way to me, and I remember Canal was a third-party action. Mm-hmm. Now, maybe the courts have done something different. I haven't researched this, and I don't know whether Judge Davis has or not, but it may be that the Supreme Court has spoken subsequently to this, or some other courts have. But if you and Mr. Rosenblum could do that for us, so you within 10, and then Mr. Rosenblum 10 days thereafter, and I'm going to ask if we can put your 15 minutes back on the clock, because it's not fair for us to take 5 minutes of your time with this. But All right, yeah, now you can proceed with your argument.
Well, we'll certainly address that. Leaving the jurisdiction aside then for the moment, we're asking this court to reverse the trial court's decision on coverage for two reasons. First, this case was settled. The plaintiff demanded $50,000 by a date certain. We delivered $50,000 by a date certain. In return, we were due to receive a dismissal with prejudice, and we did not. The trial court should have enforced our settlement agreement. And second, the insured's truck was plainly and indisputably modified. It was the suspension and the steering systems were fundamentally changed, altering the characteristics of the performance of the vehicle. Mr. Roberts turned his truck into a monster vehicle and never told my client. My client does not insure such modified vehicles. Section 627.409 is the legislative command that permits insurance companies to rescind policies when they're not given information that they ask for. And in this case, we asked for it, we didn't get the information, and we proved that it was material to our insurance on the risk. The trial court should not have strayed into the fields of ambiguity and should have focused on the legislative enactment 627.409. Those are the two basic issues that we've raised in our brief and that are between the parties. And I've got plenty to say on it, but I'd rather address my remarks to whatever questions the court might have right off the bat, if there are any. Let me address the coverage issue then first. The coverage issue was incorrect. The trial court went down this path of reasoning about ambiguity in insurance policies. What does the word modify mean? What does Mr. Roberts think the word modifies means? Mr. Roberts thinks the word modify means something about racing. Mr. Roberts, the insured who signed the application, testified that he never read the application. He testified he didn't know he was not confused by the word modified because he didn't read it. The argument about modification and whether it's ambiguous and whether Mr. Roberts understood it was invented later by the lawyers to excuse his non-revelation of this important fact that my client asked for in the application. His disclosure that he had installed this lift kit, which changed the suspension, which lengthened the steering, and the installation of the big wheels, was a modification. We asked if there were any modifications, and under 627.409, the legislature says insurance companies are entitled to rescind policies when they ask for information and don't get it, and that information is material to whether or not they would have insured the risk. We did all that. We have an affidavit of the underwriter that says we wouldn't have insured it had we known the lift kit had been installed, if the big tires were installed. In a case called Carroll, the Florida Supreme Court in 1986 said, where an insurer would have altered the policy's terms had it known the true facts, or the misstatement materially affects the risk, a non-intentional misstatement in an application will prevent recovery under an insurance policy. So it doesn't matter whether Mr. Roberts intended to hide this, whether he didn't know he was supposed to reveal it, whether he lied on the application. None of that matters. The legislature says if the insurance company asks for the information and they don't get it for whatever reason and it's material, they may rescind. That's what we did here, and that's what we proved. And that's why it was error for the trial court to avoid the application of this statute and stray into this area about ambiguity, which is really a non-issue, because Mr. Roberts testified at his deposition, pages 18 to 19, 29, 76, and 91, that he did not read this application. So he wasn't confused when he wrote it. He just didn't reveal the information he was required to reveal. That's why 409, the statute, applies, and why the misrepresentation, or rather the ambiguity argument, is a non-starter. Whether or not fuzzy dice as the trial court said, was a modification. All of that can be avoided. Focusing on the statutory right of the insurer to rescind and the evidence that's in this record resolves the whole case. If you get past the settlement issue, and there's a question I understand there as to whether or not the court has jurisdiction. We say they do. You do have a jurisdiction. Let me address the settlement issue. The plaintiff demanded $50,000, which were our policy limits, by a date certain. In exchange, they agreed to dismiss the case with prejudice. We delivered the checks. They returned them saying, you have attached conditions. There were no conditions attached. We told them we would like a release. We would like to sign this, to sign these particular dismissal documents. They were never made a condition of the exchange.
So they were free, counsel, then? The plaintiffs were free to cash your client's checks and discard the release?
Yes.
Well, then why was the release then incorporated in the judgment, i.e. the language in the judgment, the proposed judgment of dismissal stating that the liens, the other claims are paid, that kind of language?
Those documents we requested but did not require. They were all part of a package that we wanted but did not require. They could all be discarded. And Judge, had the plaintiff taken the money, cashed the checks, filed their own dismissal with prejudice, and we come back and say, no, you must also give us these releases, you must sign these further documents, and we were before the court, wouldn't the court tell me, as representative of the insurance company, that I had failed to make those documents a condition of this settlement? I think it would.
This was settled at policy limits, wasn't it?
Yes. And that gets us more towards a public policy issue, Your Honor. The bad faith, what I call the bad faith setup, and I don't mean anything pejorative about my opponents, but it is a practice, it is a ploy in the plaintiff's bar to make an offer within policy limits that they hope, they plan, or perhaps plan, that is not accepted. The insurer's liability is typically limited to the policy limits. If an offer is made within the limits that is not accepted by the insurer, then the insured, if they become exposed to an excess judgment, may go back in a bad faith claim and say, insurance company, you had the opportunity to get me out of this for policy limits and you failed to take that, and now I'm going to sue you for bad faith, and I'm going to get as my damages all the excess liability that has been foisted on me because of your failure to accept this policy limits demand. And those excess judgments are typically assigned, as it was here, from the insured person to the plaintiff. And the plaintiff, the injured person, here Markham, takes that excess judgment standing in the shoes of the insured, has that excess judgment, sues the insurance company for bad faith and says, I'm here, Mr. Markham says, I'm here for Mr. Roberts, and you exposed Mr. Roberts to an excess judgment, Mercury Insurance Company, and you're going to pay the whole $350,000 because you could have accepted the $50,000, you didn't.
I understand that, but I guess the reason I asked you the question is I'm wondering why you needed the release. I mean, if you've settled at policy limits.
We wanted it. We didn't need it. We didn't require it.
I'm having a little, I guess maybe there'd be some potential benefit, but I'm wondering what it did for you if you settled the case at policy limits. I mean.
Well, I won't speak to the legal question of the efficacy or the value of the release. I'm kind of got my hands full with the ones that are certainly before the court. I think that insurance companies are accustomed to getting releases. They like things as ironclad as possible. I think that is an expectation that they try to get. They did not require it here.
Counsel, would you address our decision, which I don't think you did in your initial or reply brief, the decision of Nichols versus Hartford, the Hartford Insurance Company, I think if I'm not mistaken, it was at 833. Southern Second, but in that case, as I assume you know, this court ruled that a release requiring indemnification was a counteroffer and nullified any obligation by the plaintiff to accept the check. Do you see that as distinguishable here? I will note,
Yes.
Of course, in that case, counsel was asked at oral argument if they
Right.
could cash the check, and you say that they could.
Yes.
But
That's-
aside from that factor, the language that was sent to the plaintiff in that case, is it different than the language you sent?
I don't know if I can speak to exact language. I think they are different in some regards. I don't think indemnification, and I'm sorry, Judge Holmes, I don't recall if indemnification is part of what was asked for here. But you've hit the nail on the head. The essential distinguishing point between that case and this is that I stand here today and say they could have cashed the check. They didn't have to we didn't make it a requirement of the offer. There was no requirement that they take the documents that we presented to them. And I think maybe there was a different colloquy from this podium in Nichols.
There was, and I'm somewhat unclear as to how counsel, in that case, our court said counsel answered the other way, and that was the distinguishing factor, and the court ruled that the insurance company had made a counteroffer. Here, I don't believe the record is crystal clear that what the plaintiff would have thought. And I guess you look at it on an objective basis under contract law, but looking at it objectively, the checks were sent. I appreciate your response, and certainly will attempt to take that at face value. But they're sent checks with a release and told, here, I hope this release is satisfactory. If there is any language you wish to revise, please call me. Objectively speaking, I'm not sure that's an indication that it was an optional document.
I think, as I recall from the Nichols case, that the release was required and was a part of the deal. And the question is, what were the terms of the release? The insurer in Nichols, I think, required or asked for indemnity and said, I'll change this if you want.
Right.
In this case, there were no releases required. And I think that's maybe an additional distinguishing characteristic of the two cases. I think they learned.
You're into your rebuttal time. We'll reserve the balance of your time for you.
Good afternoon, if it please the court. My name is Louis Rosenblum, and I represent Mr. Markham. I'm wondering if I could have just a few minutes of extra time to address the jurisdictional issue.
Sure. Why don't we just stop the clock and let you do that?
I know I really shouldn't do this, but I knew I had a note about this, the first jurisdictional question, and I had the same reaction, Judge Allen, that you did, and with the court's indulgence, can I read my note because it doesn't conclude anything. I asked, am I sure this is a case for jurisdiction under 9.110M? I'm not sure 9.110M was intended to apply to a case where the insured denied coverage, and then the case went to final judgment against the insured, and then the injured party sued the insured and insured to collect on the judgment. I then note that the committee notes, as Judge Davis mentioned, state the rule was intended to expedite review, quote, where a claim against the insured is pending, and I underline pending, and early resolution of the coverage issue is in the best interest of the parties, close quote. Then I note the claim is not, quote, pending, it's going to final judgment. And then I think the court will find my last comment amusing. It says, what does Padovano say? Because I wanted to go to his book. But here's the point I want to make about why I didn't object to jurisdiction. I vaguely remember doing some research and finding a case from another district that didn't really discuss jurisdiction, but it says we have jurisdiction under 9.110M, and it was the basic same procedural facts we have here, where the underlying personal injury claim had gone to judgment. So I said, okay, the court has jurisdiction.
Maybe they just didn't think of it, Mr. Rose.
Well, I don't know.
Maybe they don't understand the rule.
And I was satisfied, of course, for the court to have jurisdiction and get it resolved. The second question I have about jurisdiction is I'm concerned whether the court has jurisdiction to entertain the non-final order determining that there was no enforceable settlement agreement. And the reason why I mention that is Rule 9.110M gives the appellant the option of proceeding as a final appeal or a non-final appeal. Well, if it's a final appeal, the court can consider any interlocutory order. But if it's a non-final appeal, it can only consider the non-final order that gives the court jurisdiction. Now, whether that rule applies to this case, I don't know. There's obviously no case on it, but I mentioned that in my brief, and I said in my brief that I take no position on it, and I don't know whether you want that included in our memos.
Well, you've already addressed that.
I have.
And I think they responded. I think I read that in both your briefs.
And the court found that this would proceed as an appeal from a non-final order.
I understand.
So I don't know whether the court has jurisdiction or not.
Okay, now we get
that said, let me begin my argument by making a couple of objections, if you will, to things that are in the brief. On the first issue, on the insurance coverage issue, the appellant has appended to his brief some kind of technical journal article about vehicles that have been jacked up with lift kits and so forth, and that was not part of the record, and I object to any consideration of it because it explains how you do it and what the hazards might be. None of that's in the record.
Did you move to strike that already?
No, I just put a footnote in. I put a section in my brief and asked the court not to consider it. I find the motion to strike is not a very useful tool because it's generally denied, and I don't know why, because I don't know if it's because my argument has no merit or the court's fully capable of dealing with it without striking a brief. The second thing I object to, and I didn't move to strike it again, is in the reply brief, which I don't have a response to, and it's not a big deal, but there's a statement in there that Mr. Markham's lawyer could have gone down to the Bank of America office in Lake City and cashed these checks and got immediate funds for them, and then there's a footnote with the addresses of the two Bank of Americas. Well, there's nothing in this record to indicate that there's a Bank of America anywhere in the state of Florida. I know there is, but I sure don't know if there's one in Lake City. That's not going to make much difference, but I just wanted to mention that. And the other thing, before I get to the merits, is my opponent, I think, has spent more time in his argument talking about the bad faith case that's not been filed and not the case before us. And, to call what went on here a ploy, I take exception to that. And, it cuts both ways. Insurance companies relying on a technicality to beat the insured out of coverage is also a common ploy. And that's why we end up here before the court. Now, let's talk about the insurance coverage issue first. Forget for the moment whether Mr. Roberts, the insured, read the application or not, or whether the agent saw the vehicle or didn't. None of that matters because the question of whether the application is ambiguous is one of law for the court to determine. All of this other stuff about what the insured testified to and things of that nature is, it's really irrelevant. It's a question of law. The court looked at the application and he said the word modify is ambiguous. And it's ambiguous because it's susceptible to more than one reasonable interpretation. For example, the question states, is any vehicle rebuilt, salvaged, modified, altered, or specifically built? I think they probably meant specially built, or customized. Well, a specially built customized car, I don't consider this one. I think of a dune buggy or one of these kit cars, or maybe they've taken a sedan and chopped off the top. And the more specific, under rules of construction, the more specific terms don't take precedence over, but give you the flavor of what the more general terms like modified or altered mean. This was not a rebuilt car. This was not a salvaged car. It wasn't a specially built car, and it wasn't a customized car. Was it modified? Well, what does the word modified mean? Does it mean a kit car or a dune buggy? Does modified mean a lift kit? Or does modified mean you put an accent stripe on it or a stereo? And the insured's testimony, although I say it's not relevant, is a good example about how ambiguous this question is, because they asked him in his deposition, was your vehicle modified? He said, well, I had, that was his first comment. Later said the question's kind of vague, but he said, well, I had the oversized tires and I had the lift kit, but then he said I also had the stereo. And, you know, I am familiar with what modified cars are in racing. So the point is that the ruling that the judge made, which was one solely of law, is that the application is ambiguous. And when the application is ambiguous, you can't give a wrong answer. When either yes or no could be correct, depending on which definition you use.
Counsel, putting large tires on a truck and rendering it, I assume you don't agree it's a monster truck.
That word's not on the record either.
Putting large tires on a truck and a lift kit, you think a person being asked that question, being asked, have you modified your vehicle, would be confused and wonder, gosh, I don't know what modified means. I'm not sure that I've modified it.
Well, in Lake City, all the pickup trucks look like that. But, well,
That's quite a generalization.
I'm sorry about that. I'm not,
And it's also not in the record.
I'm not disagreeing in concept with what you say. But what we've got to ask, you know, what does is the word modify ambiguous? Does it mean an accent stripe? Or does it mean, like the agent's manual says, a dune buggy or a kit car? I don't think any of these answers are, you know, if this insurance company really wants you to list every modification from the accent stripe all the way to the chop shop, well, then I guess his answer is wrong. But I think it's quite unclear, particularly when you look at the policy, and my opponent says my client does not insure modified vehicles, but it does. It insures, not for liability maybe, but the property damage portion of this policy. It insures custom parts, modifications. It doesn't give you full coverage for it. So, you know, that's another thing that adds to the ambiguity here. Now, another thing, if you look at the agent's manual, again, I don't think you have to reach that, but it describes unacceptable risk as rebuilt, salvaged, altered, modified, specially built kit cars, customized vehicles, and dune buggies. Well, again, I cited some Latin term in my brief that I can't pronounce, but the general words take their character from the specific words. So if I were giving this a definition, I would say it's something like a dune buggy or a kit car. Now, whether, you know, we don't know all of this stuff about how do you lift the thing up. I think most of that is in that hearsay article that wasn't in the record. So anyway, I think it's a question of law. But one thing I want to make sure the court understands, if for some reason you disagree with me, insurance company doesn't win the case, because we still have the issues of fact about whether the agent saw the car or didn't see the car, or the truck rather. And there's a dispute about that. And then we have the question about whether the agent was an agent of the insurance company or the agent of the insured. And then we got the question about whether he read it or he didn't read it. So, you know, that would require trial. But I would respectfully submit that because we have this, because the question is ambiguous, there is no incorrect answer. And we cited 3 cases in our brief. One had to do with about whether the insured had cancer, and it was, you know, it was unclear whether that meant now or in the past. So either way, yes or no, the insured couldn't lose, because both of them were correct, because the definition wasn't clear. And there's 2 other cases that ask you who the drivers are in the car, and they weren't specific in your family, and they weren't specific about whether they mean permanent residents or temporary residents and so forth. So in both of those cases, the courts held that the question was ambiguous. But the thing that's common to all 3 of them is they were all rulings as a matter of law. 2 of them affirmed summary judgments for the insured, and one of them reversed a judgment for the insurance company with directions to enter final judgment for the insured. So, you know, even though Mercury says they want their day in court on whether this provision is ambiguous, I don't want to overstate it, but it's a question of law for the court to determine. Now, moving to the settlement issue, let me respond about the general release by saying, let's assume that that's not even in the case. The settlement offer said, we want $50,000 by a certified cashier's check, and as soon as we cash the check, we'll dismiss the lawsuit. That's all you need when you have a final judgment. You don't need a release. You satisfy the judgment, which you're required to do by statute. So let's forget the general release for a minute, although I find it almost preposterous that an insurance company would send a release with no expectation that you sign it. But anyway, they did send the dismissal papers. That was part of the settlement. And the dismissal papers that the trial counsel sent, she already signed the stipulation for dismissal, and the stipulation says that the plaintiff has paid all the medical bills and satisfied all outstanding liens. Well, the record shows this guy didn't have any health insurance. That's a deal breaker. That's not part of the settlement offer. And to make it worse, she sent a proposed order that the judge was going to sign, ordering him to pay the medical bills and satisfy the liens. So if he didn't pay the hospital, he's in contempt of court. Well, I'll respectfully submit to you that that is not an acceptance of the settlement offer. The other problem with the settlement, and the same holds true with the general release, because to require the plaintiff to state that he satisfied all liens and paid all medical bills, again, that's a deal breaker. Furthermore, they didn't. I admit it was somewhat, not entirely clear when the injured party's counsel requested a certified cashier's check, because there is really no such thing, but the insurance company wrote back and said we can't get a cashier's check. So they knew what he was talking about, and they didn't give him a cashier's check, and they didn't give him a certified check. They gave him a regular check. And well, why is that important? Because by asking for a certified check or a cashier's check, you're telling the insurance company, I want immediate availability of funds. And under federal law, the longest it can take for one of those to clear is 1 day. With a regular check, I don't know. The insurance company says he could walk down to the Bank of America in Lake City and cash it right there that day. I don't know. But that was the other problem. So even assuming the court has jurisdiction to entertain that order, the acceptance has got to be exactly like the offer, and clearly it wasn't. So
you would suggest it's controlled by Nichols? Nichols v. Hartford.
Well, Nichols is certainly a good case for it, because the release there had the indemnity agreement, which is much like the payment of the medical bills or satisfying the liens. But I think the important thing about Nichols is it says, what's basic contract law is that your acceptance has to match the offer as to all essential terms, and the essential terms were, obviously didn't include that. So for all those reasons, I respectfully request that you affirm, assuming you have jurisdiction.
All right, thank you, sir. Mr. Russo, you have a couple of minutes remaining for rebuttal.
Well, thank you. If there's only a couple minutes, are there any questions off the bat that I can respond to or direct my comments to? Just let me leave the court then with this. When we come in through these doors, let's not leave reason and practicality outside. We have a business to run here, selling insurance. That insurance is sold by asking people information about the risk they want us to insure. The legislature has established a scheme whereby we get to ask questions about information that's important to us. The insured has to answer it. And if they don't answer it, regardless of their intention, regardless of their understanding, we get to rescind. That's what the legislature said. It is not a technicality. It is a piece of Florida jurisprudence. This question could not be answered yes or no. The vehicle, and there's pictures of it in the record at A21, which is a deposition, I think of Mr. Roberts or Mr. Markham. Exhibit 2, there's pictures. You can see it all jacked up with the alterations to the suspension system. That is a fundamental alteration to a car. You can't answer no. Knowing that you have done this to your vehicle, you can't answer no to the question, is your car, has it been modified? If it's a health insurance application...
But you're saying he didn't read the policy, so he didn't answer the question.
That's right. And he had an obligation to read it and give us the information. By not reading it, he violated his responsibility to give us the information. The statute doesn't say if the insured reads it and doesn't give you the information on the application, then you may rescind. The statute only says if you ask for the information and don't get it, nothing can make an insured or an applicant read an application, but they have an obligation to do so and to answer it. His failure to do that resulted in this violation, which permitted us to rescind. And let me say, as to not every modification, let me get this right, not every modification precludes an issuance of an insurance policy. I did not say that my client does not insure modified vehicles, as I think my opponent misspoke. I said my client does not insure jacked up vehicles or vehicles with lift kits on them. Not every modification will preclude coverage. My client has underwriting guidelines. My client considers some modifications to preclude its coverage. Others it does not. But it asks that all modifications be revealed to it so that it can make the determination it needs to make to underwrite and sell the insurance. It may be that one modification, like tinted windows, doesn't matter. It will issue the policy. It may be that an air spoiler on the back lid doesn't violate its guidelines. It will issue the policy. It may be that others would preclude the coverage.
Your time's expired, Mr. Russo.
Thank you.
Thank you both. And remember to let us hear from you on the threshold jurisdictional question. Beg pardon? Oh, yeah, sure, that's fine. And as I say, if we could hear from Mr. Russo within 10 days, and then Mr. Rosenblum, you'll have 10 days there to respond. All right, that